Professor Maniatis, thank you very much for that absolutely spot-on introduction. I must say, extremely comprehensive. And I just want to take a couple of your thoughts forward, because you've very graphically described some of the opportunities in this whole area and the way that AI and data can combine in a very beneficial way. And of course, what we all need to be aware of with AI is the opportunities, but also the risks. And in a sense, and I'm extremely grateful to APELIA, the Asia Pacific Law Institute Alliance, and BICL for organizing today, because we're going to be looking in a more granular way at some of those risk issues, both in terms of trade and the use of data, the sort of data that is now the subject of trade deals. We're seeing that very clearly in some of the deals that the UK is now post-Brexit agreeing. But we're also seeing a movement in terms of hard and soft regulation by organizations like the OECD, the EU, Council of Europe, and indeed private sector initiatives such as the BSA Software Alliance in terms of corporate governance. So it's a very, very live issue, and I can't think of anybody better to kick us off than our three panelists today. And we're going to go from the more general to the particular, both in terms of the kinds of regulation that can be envisaged, and in terms of the AI itself, the applications itself, and then we can unpack with questions from the audience how or whether it's appropriate to regulate any of those applications themselves. So I'm going to start with Youngzi Kim, who's the Assistant Chief Executive of the Infocom Media Development Authority and Deputy Commissioner of the Personal Data Protection Commission in Singapore. And he's going to open by talking to us about smart regulations, implementing a responsive regulatory regime. Over to you.
Thank you, Lord Clement Jones. It is my pleasure to be given this opportunity to share a view, right, from Singapore of our experience in implementing smart regulations. And what I plan to do is really to commence by establishing overall frame of what smart regulations should look like. And then I will spend the rest of the time that I have to talk about how we've taken a different approach towards smart regulation, particularly in the area of artificial intelligence, through a soft law option, right, a voluntary standards option, right, and that might actually be in contrast with a slightly different approach that colleagues from the EU are probably in the midst of discussing with the draft AI Act that has come out in the last couple of months. So if I can have my slides on screen, I'll just crack on and get started with my presentation. Thank you. Now, can I move on to the next slide, please? Now, as the slides load, I thought what I will try to do is really to try and distill what do we mean by smart regulations, and why is it important in an area like artificial intelligence? Smart regulations as a term is not new. Writings have been put forward on this topic by academics since the late 1900s. Well, sorry, the 1990s, the late 1990s, right? And there have also been numerous, a number of proposals, right? One by the European Commission about smart regulation in the EU, and more recently, a draft recommendation by the OECD on what an agile regulatory governance framework should look like in order that we might be able to harness innovation. So I would distill the five principles here in designing smart regulations. Now, starting from the top, right? We need to take a holistic approach in the sense that we need to we need to look at smart regulations from in a way that involves different aspects of the whole policy cycle, starting with policy design, moving on to how the regime is administered and if there are laws enforced, right? And also continually monitoring, right? To ensure that it is effective. A second principle is that it has to be inclusive in the sense that it needs to take on board the views and the views of those who are regulated by this regime, right? So stakeholder engagement should commence with consultation at the policy design stage, but it should not end there. There are proposals, particularly in the OECD draft recommendations of concepts like self-regulation and co-regulation as part of what smart regulation should look like, right? One particular example that we're going to come back to is the next principle, that it should be incremental. Incremental in the sense that we do not start with prescriptive legislation or regulation, but we need to consider using different types of policy instruments, starting with the lighter touch ones and increasing the prescriptiveness as the situation develops. It needs to be responsive, the fourth principle. Responsive in the sense that we need to make sure that you continually assess the impact and effectiveness and make adjustments, right? Changes along the way, right? And finally, it must be supportive of innovation. And that's one of the things that we are going to come back to. Next slide, please. Now, so taking these 5 principles on board, right? What does it mean when we want to translate this into a set of implementation principles? Now, this is where I depart from the tried and tested, where I draw some analogies, right, of from smart home devices. What are the 3 characteristics about smart home devices? They're connected in the sense that it is able to sense and take in information from its environment. They are intelligent in the sense that taking the information from the environment, it is able to respond in a way that serves its users, and it is contextual and relevant to where you are, right? And it is data-driven in the sense that, data, right, is collected, analyzed continually, and then it is then used to predict, right, or recommend the next step. Now, can we also take this approach when we talk about designing smart regulations? Are we able to make sure that our entire regulatory framework, right? We talk about how the smart regulations need to be holistic. Can we ensure that the entire framework, right, is connected in the sense that it is always sensing the needs of the sector, right? Intelligent in the sense that when we design our intervention and our policy responses, are we able to calibrate it to respond to the needs of consumers and the businesses who are regulated? And then, of course, can we also take a similarly data-driven approach in that we analyze past data to ensure that the next steps are predicated on the past, and people are able to better predict, right, what we might do, right? Next slide, please. I do believe that we can, right? And in this slide, what I plan to do is really to illustrate through examples from the experience in Singapore on how some of this might happen. Now, I don't have time to go through each of it in detail, but I will just pick out 1 or 2. All right, one example from each box. Connectedness. Now, how can we be connected to the industry that we are regulating and to sense the need of the sector and the industry? I think one of the things that we did, right, was to go beyond consultation, whether it is a closed consultation with trade associations and chambers or open public consultation, but to see whether we can get the regulatees to be involved in co-creating a set of principles. And that's something we did. We appointed a committee to look into articulating a set of principles that can support the use of personal data for business improvement purposes. The committee made its recommendation. These were studied, adopted. We went through public consultation, and just about half a year ago, right, they were enacted into legislation when we amended our Personal Data Protection Act, and we have a set of exceptions to the consent requirements embedded in our law to support the use of personal data for business improvement. And this is something that is co-created, co-designed with the industry. The next principle, intelligence. I will spend a bit more time talking about our AI governance framework, so I will skip over that now, right? And very quickly, just talk about the third angle, data-driven. Are we able to use data, analyze data from the past in order to guide our next steps for future action? There are a couple of examples that I can cite, right? One will be looking at past cases in order to identify what are the common causes for data breaches in Singapore, right? And then producing a handbook that provides not just the common causes, but also matching that with examples from the cases in the past, and more importantly, the steps that can be taken to prevent these data breaches for the future. And that to me is one of those examples where it can be data-driven. I'll spend the remainder of my time talking about how we can have intelligent regulatory framework for an innovative area like AI governance, and how we can respond to the industries and consumers' needs in doing so. Next slide, please. So in the area of artificial intelligence, right? One of the things that we receive constant feedback, right, from the industry that while AI as a technology is not new, a term that has been around since the 1950s, but the variance, maybe the wrong word, but the variety that we are dealing with this last 5 years or so, machine learning, which is data-driven, right, is still an emergent technology. Emergent in the sense that the technology is still being developed. The way that it is used by industry is still evolving, and there's still a lot of uncertainty. So how do we deal with an area, right, where innovation is happening constantly? So one of the things that we thought of was to see what is the level of regulatory response that we need to take, right? And this is an example of how for an area like AI governance, we decided to go with a voluntary set of standards through our model AI governance framework, right? A soft law approach, right? To introducing a framework that is based on the principle of accountability, ensuring various aspects, right? So ensuring that the management is accountable by making decisions at the right level of management, ensuring that there are good practices so that you're accountable for how data is used, model is eventually selected for deployment, and how you monitor performance, right? Accountability also in the sense that you know how to manage the level of information and the nature of communication that you want to have with customers that you have. So it's based on the principle of accountability. It is a voluntary standard. It is soft law. So that's one example of how we introduce this. The other point I'd like to highlight is that we were also sensitive to the fact that many of the organizations don't know how to implement a system like this. So there was a need for guidance, right, in the form of examples from a real world use cases. So we put together a compendium of use cases so you can learn from others who are doing the same thing as well, and also putting together a set of self-assessment questions, right, to guide you to make sure that you have done it well. So again, responding to the needs of the industry, not necessarily in the sense of regulation, but in the sense of the support that they require, right? I'll just end off with one last point about this framework, which is a point that was made by the OECD recommendations, that even though these are voluntary frameworks, they need to be underpinned by law, right, on legal liability. And this is actually underpinned by the personal data protection laws in Singapore, where when you are dealing with personal data and using it for artificial intelligence. And if time permits, later on I might share one particular case that we decided recently, where the fact that the company that was involved had policy statements that explained how they make use of artificial intelligence in conformity with this governance framework was actually something that was taken into consideration in the company's favor when we were deciding a case. So I hope to maybe we have a chance to talk about that later. So I'll end my presentation here, right? And I hope that we will have time for a more in-depth discussion on this and other topics during the Q&A. Thank you.
Kin, thank you very much indeed. A really interesting presentation. And I just want to unpack something with you, because it's a very interesting approach that you're adopting, which is soft regulation effectively, but underpinned by a fairly strong data protection regime. Do you not think that, in a sense, the risk issue relating to AI in certain applications, as the EU has put forward, requires also some legal underpinning as well? Or do you think that your use case guidance will be enough to, in a sense, steer people away from misuse of AI?
Well, thank you. I think very quickly, all right, I think that there are pros and cons to the approach that Singapore has taken. It works well when you are working with personal data, and the personal data protection law is there to take care of the risk, right? But if you're not working with personal data, if you're dealing with machine data, then it will not be governed by our personal data protection laws. And I think an approach that is more broad-based, like what the EU is considering, right? Particularly when they're talking about high-risk application of AIs, especially in safety components, right? Those, I think, are found mainly in industrial application. And I think those are the areas where you might actually need something separate. I look at the draft AI Act today, right? And I actually kind of characterize it as a form of sectoral regulation, because it's really focused on a fixed list, right? A finite list of high-risk application. And I think sectoral regulations like that might work as well. So it's something that we've been studying, and I would say that, well, the days are early, and I think that we need to explore and see the different approaches and see what works better.
And the other question that, of course, arises, can any country be an island of legal of a legal regime? You've talked about the OECD, we've mentioned the EU, there are other bodies, international private sector bodies too, involved in the corporate governance agenda. Do you think this has to be an international approach?
Definitely, most definitely, it has to be an international approach, because I think the innovation that's happening these days, particularly when you're talking about AI, it uses data from multiple markets, right? And the features are introduced into products that are also made available across multiple markets. It's absolutely necessary that we come up with standards that are interoperable. I would not dare to say harmonize at this point in time, but at least let's strive for convergence, interoperability. And I think that there are significant efforts happening right now. The OECD has got this conversation going on. The Global Partnership for AI has some conversation going on as well, right? And I think UNESCO recently is also working on a set of recommendations. Yes. So I think we need to work towards that.
Great. I like the word interoperable. We'll unpack that later, perhaps. And so we move on. Thank you very much indeed. And we now move on to Professor Zhaowen Zong, who's the Dean of School of Law at Shanghai University of Finance and Economics and Vice President of the International Economic Law Research Association of the China Law Society, China. How will fintech influence the world development? That's a big subject.
Thank you so much, Lord Jones, and thanks for BICO's invitation. Thank you, Cyprus, Professor Cyprus. And it's also my honor to be here to share some thinking on fintech. We know it's very interesting about the development of fintech. Why? Because it's developed so fast, and it brings many risks unknown to the humankind. So please give me some seconds to share my PowerPoints. Well, was it okay? It's okay, right?
That looks good.
Okay, thank you. Okay, why is fintech widely concerned? For so many years, financial market has drawn many folks out of human being. And in recent years, fintech has risen rapidly all over the world. But some business involve breaking through laws and regulations, which has accumulated certain potential risks and caused widespread concern from all aspects. For example, some international organizations and some countries' regulatory authorities, such as FSB, and IMF, and Payment and Market Infrastructure Committee of the Bank for International Settlement, and for example, the European Central Banks. Okay. And if we go forward to talk about some main development of fintech, I think these following technologies may be, among all the technology, may be the most important. For example, distributed accounts, blockchain, Bitcoin. Okay. About distributed accounts, we know it's a technical mode scheme, may be very complicated. And this scheme is proposed to realize the synchronous recording of participants' trading activities in the network. And this is the definition given by FCA of United Kingdom. And the data records shall meet at least 4 conditions. First, uniqueness. Transactions and records corresponding one by one. And the second one, the record should be continuous and uninterrupted. Third one, the record format standard is unified. And the last one, encryption should be tamper resistant. So there are many very strict conditions requirements. At the present, the main application fields are up to now: transaction bookkeeping, asset confirmation, and identity verification. The second important technology is blockchain. It's a very famous technology up to now. It's the most important and representative technology of the former technology, that is distributed account. Okay, specifically, all participants in the network record a certain transaction information synchronously and verify the authenticity of the information to prevent the information from being tampered. It was first used in the generation, storage, and the trading of Bitcoin, also a very famous currency, and other digital currencies. And at the present, it's employing to expand to payment and clearing, accounting, auditing, securities trading, risk management, and other fields. About digital currency. Now, many investors among the world very like this kind of digital currency. But what is digital currency? It's also called cryptocurrency or virtual currency. And according to the issuing entities, this kind of currency could be divided into legal digital currency and private digital currency. And the Bitcoin is a kind of private digital currency. And legal digital currency is a kind of digital currency issued by, we know which one, central bank, in accordance with the law, okay, which has unlimited legal compensation, value scale, circulation means, payment means, value storage and other functions. That is legal digital currency. And what's private digital currency? In theory, many countries, authorities, and scholars argue that private digital currency should not be called currency. Why? They argue that its essence is a digital symbol designed and issued by market institutions or individuals themselves and agreed to apply rules. In nature, it's similar to commodities that can be circulated within a certain range. So we know as a typical private digital currency, Bitcoin is the first practical application case of blockchain technology in the world. Relying on the concept of Bitcoin, financing activities such as initial currency offering have emerged in the market. So, how to evaluate, how to look at this kind of development? Maybe the attitude of some important international organizations and the regulatory authorities is to some kind is very important. So let's look at the discussion of these issues by some organizations. FSB, Financial Stability Board, up to now is a very important international financial regulatory standard setting body. In February 2016, the FSB had a meeting at the Federal Reserve of New York to just discuss the development and the potential impact of blockchain. Participants at that meeting reached a preliminary consensus. So what's their opinion? They said that we should pay more attention to and monitor the development and application of blockchain and maintain full communication with the industry. But there is no need to formulate special laws and regulations at this stage. So this is FSB's attitude. So what about United States attitude? According to the United States Securities Regulatory Commission, the application of blockchain in securities activities only use the distributed accounting method to replace the traditional central accounting method, which changes the form of transactions, but they think does not change the nature of transactions. This is the most important. Therefore, it is still necessary to strictly abide by the laws and regulations of securities activities and accept supervisions. So that's the attitude of SEC. To this day, this international organization and some countries' authorities' attitude is still be maintained. Okay. And many countries' authorities maintain this principle of technology neutrality. What's that? What's the principle? Okay. In United Kingdom, one of the United Kingdom's financial authority is Financial Conduct Authority, FCA. The FCA said it would always adhere to the principle of the technology neutrality, not in accordance with type or specific form of technology, but to regulate financial activities and institutions. As far as distributed accounts are concerned, it's not necessary to change the existing regulatory system and method at this stage. So this is the FCA's attitude. They maintain to keep this rule, keep this principle. The same attitude we can find in Swiss and the French authorities' attitude. But is there any potential risk of this principle? Although these authorities, they maintain this principle, we still need to think about whether there is potential risk of that. We have known that this technology have bring very big technology risk. So what is the technological risk? It's unknown. Many of these risks are still unknown. But why? The second question, why still many authorities, they decided to choose this principle? Maybe just because of the uncertainty. Uncertainty, we know, means two phases. And the second point, maybe understanding. We should keep to understand the potential risks of this technology development in financial area. And the third one, maybe mitigation. We should find some methods to mitigate the risks caused by technology. About digital currency, it's also a very interesting area because currency is always interesting. There are different attitudes toward private digital currencies. Whether this kind of digital currency could be called as currency, or it's just a kind of financial instrument. Is there some certain conclusion on that? Up to now, some countries' central banks and regulators in many countries, generally up to now, they say that private digital currency is not a currency in essence. Why? Because it's not universally acceptable and legally compensable. At the same time, in view of volatility of the exchange rate with sovereign currencies such as United States dollar, its market risk, liquidity risk, and credit risk may affect consumers' rights and interests, financial order, and social stability. About whether the private digital currency could be called a financial instrument, still there are different attitudes. Okay, for example, the German Ministry of Finance believe that digital currency is a financial instrument. They believe so. While the European Banking Authority and the British Financial Conduct Authority said the digital currency itself is not a bank deposit or financial instrument. Different. Okay. According to the Federal Reserve, digital currency lacks intrinsic value, is not supported by safe assets, and is not a liability of any institution. So it is difficult to simply characterize it. However, at the same time, the United States Commodity Futures Trading Commission believes that digital currencies that meet the commodity characteristics defined in the Commodity Trading Act should be regulated by bulk commodities.
We need to start wrapping up, Professor.
Okay, so we go to the last one, some suggestions. Okay. Follow the principle. Maybe it's up to now, is a reasonable principle, and implement regulation according to nature and financial business. The third one, according to my opinion, is a very important one. Maintain fair competition in the financial market and strengthen the understanding and monitoring fintech's risk, outsource risk, and other operational risks. Okay, thank you very much, Lord Jones.
Thank you very much indeed, Professor. I'm really interested in your final conclusion, because throughout your presentation, you seem to be criticizing the principle of tech neutrality, but then at the end, you say, okay, we'll follow that, but then we'll look at the nature of the business. Is that because you don't think you can get international agreement on a regulation which is specific for distributed ledger currencies, cryptocurrencies, and so on? Is that because you're rather pessimistic about being able to get specific regulation to deal with that kind of risk?
So in this slide, I just give a little discussion on this principle. Okay. I believe there are some potential risk if the authority maintain this principle, technology neutrality, because there is uncertain risks. But the next paragraph, I just analyzed why still to choose it. I don't know whether it's correct, but I pose 3 points I think maybe could explain why to choose it. The first is uncertainty. Just because of uncertainty, we don't know whether this risk is big enough, serious enough, or maybe beneficial enough to the financial regulation. Because the risk may be harmful to the financial market, may be harmful to the financial regulation. However, the other aspects may be beneficial to financial regulation. We don't know. So it's a chance. And the second point, understanding. Understanding means the authority should seek any chances to cooperate with industry, with technology industry, to know where is the risk, what are the risks. And the third one, to find ways to mitigate these risks. Okay.
I think that is that's very clear and very useful. But of course, you know, the risks of cryptocurrencies are becoming more obvious every day, aren't they, in that sense? So you think that if it becomes more certain about what the impact of cryptocurrencies are in a risk way, that we might eventually adopt specific regulation? Or will you always have the view that tech neutrality is the right way forward?
My opinion is that because of the uncertainty, so maybe diversity up to now is a better choice, maybe. For example, according to the uncertainty of risk of private digital currency, there are up to now mainly 2 types of regulation. The first one is just as China, okay, to restrict or even prohibit the financial business. Okay, this is one model. Up to now, we could not draw the conclusion whether this method is better than the second one. And the second one is to, well, don't prohibit, don't restrict, just bring this financial business related to private digital currency into the current regulatory framework. Okay, so which one is better than other one? We don't know, just try, maybe just try.
Great.
Okay.
That's a
Thank
good
you.
message. Thank you very much.
Thank
And
you.
now for our third panelist, we move to Professor Maria Liakata, who's a Turing AI Fellow and a Professor in Natural Language Processing at Queen Mary University of London. And she's going to talk about towards creating time-sensitive sensors from user-generated language and heterogeneous content. And no doubt she will explain exactly what that means, Maria. Thank you.
Thank you. Could Chan put my slides up, please? Thank you very much. Can everyone see them? Great.
Yes. Yes, right.
Thank you. So I will let you know when I want them advanced. So first of all, I'm honored to have been asked to talk. I'll try and stick to my 10 minutes or less if I can. Yeah, so a lot of the work that I'll be discussing today is in the context of my Turing AI Fellowship. And so I wanted to, next slide, please. So I first wanted to give some context around the area that this falls under. So this falls under the area of natural language processing, which is the field that studies computational methods for getting computers to perform useful tasks involving human language, and also identifying structure and text. And it's also concerned with the insights that such computational work can give to human processing of language. And methodologically, there are important overlaps with machine learning. However, it's more than machine learning because it involves a lot of it is about human knowledge and how to represent it and how to perform also common sense reasoning tasks and reasoning tasks and inference. So, so this is kind of the general overview of the area. And we have achieved a lot so far in the field of natural language processing. So it's a subfield of AI, I forgot to say. We've managed great advantages in text classification. We've made great progress in hard problems such as machine translation and question answering. However, there are still some important challenges remaining. And so please go to the next slide. So yes, challenges so far. So we still are not very good at dealing with small data and transferring learning across different domains. We still need to have better representations of language that are also more interpretable so that we can mitigate biases in the systems that we create. We can understand why our systems make certain decisions. We also need to become better at the collaboration between humans and machines to resolve different tasks. And finally, there are still complex linguistic phenomena such as ellipsis and so on, and anaphors and so on that we still need to do better at. Next slide, please. So what do we mean by user-generated content, which I mentioned in the title of my fellowship? So as individuals, we produce large amounts of data, and these can be from social media posts, including text. There can be images, videos, location information. We also have data from other devices that we use, such as mobile phones, fitness devices, and so on. And so all of this data is called user-generated content, and it contains cues about our behavior. Next slide, please. So what we want to do in the work that I'm kind of doing in my fellowship is to create a new area within natural language processing, which is about personalized longitudinal language processing. So this is basically creating methods for capturing changes in individuals over time from their language, and using these as digital biomarkers to develop sensors and use these to understand the evolution of an individual over time. And we are particularly interested in applying this technology to make a significant contribution to mental health by creating tools that are based on these sensors and make it possible to assess and measure conditions in between clinical appointments. So I just kind of some more motivation. So why is it really important to create such time-sensitive sensors where, so obviously we produce a large amount of data that give these behavioral cues about us, and the sort of looking in particular at how to apply this to mental health is really important, because according to the World Economic Forum, mental health disease accounts for 35% of lost work output, which is twice as much as cancer and more than cardiovascular disease. And there's already work at the intersection of natural language processing and mental health showing that signals for the diagnosis of certain conditions can be found in language. And increasingly, the clinical community are looking for new and better diagnostic measures and condition monitoring tools. So I think I'll skip the next slide in the interest of time. So yes, so we have two particular use cases in mind, and these are, next slide. It's changes in cognition, one of them. So let me see if we're at the right slide. Yes, and mood instability. So, so imagine that your computer has an application that allows it to track changes in your language use over time and is able to present you or people of your choice with evidence that there is a sustained change in your linguistic ability. Or imagine that you have bipolar disorder and that your device can combine your written, spoken, and other digital content over time and can create a timeline with supporting evidence that alerts your doctor, yourself, or other individuals of your choice that a manic or depressing phase is coming up. So these are the kind of things that we hope we can get out of the methods that we actually develop. And next slide, please. So there are important challenges in developing such sensors, and here I'm going to focus on the technical challenges, but I will also touch upon ethical challenges, which I'm sure you may want to quiz me about. So yes, so technically, one of the important issues is how actually we represent individuals through both their language and their heterogeneously generated content over time, where these streams are asynchronous. So the data that we have from the different modalities are not necessarily from the same time. And so what we want to do is be able to learn dynamic user and language representations, which do not make linear assumptions about the relation between the two. So so that's actually one major technical challenge. And next slide, please. So another big challenge is how we obtained large longitudinal data, the issues that we have therefore with data sparsity, and then also how we make sure to maintain data privacy, and when we're working with this sensitive real world data. And so at the moment, we're working with small data sets, which are people who've given consent in providing all of this heterogeneous data. And we have examples from students, but also from people with dementia. And then we're also, next slide, please. And then we're also working with with data from large peer networks, such as TalkLife and Mumsnet, which have millions of posts and millions of users. Of course, they're not all as active. The data is a lot more sparse, and the kind of the ground truth we have about this data. So in the other smaller data sets, we have things like diagnosis and cognitive tests. Here we don't actually know very much about the users. So there's all these challenges about how you work with this kind of data, how you obtain ground truth for this data, how you train models which you can then share, and then the creation of also synthetic data to preserve anonymity when sharing with other researchers these kinds of data. Next slide, please. Yes, next slide, please. And sort of another important challenge is how we identify moments of change for individuals, and also clinically meaningful tasks that are based on these moments of change. And we look at both discrete change points and also about on sort of looking at more smooth changes in a user's representation. And next slide, please. So finally, there's the issue of how we actually develop. We have real-world evaluation settings for these, for training our models and for what we measure, and how we do co-creation, and also how we create summaries that can be interpreted by experts. Final slide, please. And so we plan to create sort of series of different things. So personalized methods for personalized representations, synthetic data generation from this content, longitudinal predictions, and of course we want to have interpretable summaries, new instruments co-designed with clinicians, and of course a real-world evaluation framework. So I think this is kind of in summary, you know, what this area is about, and yeah, I'm happy to have questions, and I hope this you could see it perhaps as a particular use case, such as mentioned earlier by our first panelist.
Maria, thank you very much indeed. That is a really interesting presentation. I'm just going to ask you a question before I come to back to the whole panel, and I'm going to ask the panel to look at Simon Chesterman's question, which is in the Q&A. If our panelists could look at that, and we'll come back to them very shortly. But Maria, let me just ask you, it was very interesting because you talk about the issues involving data and data protection, and you touch on ethics, but you don't go on to talk about any regulatory or risk framework. And when you talk about the tools at the end in your last slide, you don't refer to impact assessment or audit or whatever. What's your view about, because you know you're in a very sensitive field there, hugely beneficial if it's used in the right way, but it could be quite invasive if used in the wrong way, couldn't it? So how do you think that we should be looking at this, soft or hard regulation effectively?
So it's quite tricky. So what we're doing at the moment is we're consulting with both clinicians and so the experts in ethics at the Alan Turing Institute in terms of, so what are best practices in terms of you know, what we decide about the models we train, how we share them. I mean, I definitely think that there has to be a regulation in terms of, well, who has access to what we share and what purpose they're requesting it for. So I do think there has to be some level of regulation, because if you know, if we release open source code and then we want to, you know, our intention was to use it to help identify vulnerabilities and you know, how mental health condition progresses, and then someone else takes the same code and uses it to monitor their company employees, for example, I think that's quite problematic. So I do think that there needs to be some regulation, but perhaps not necessarily. And I think the other important thing to do is there's an increased interest within natural language processing on how what we develop can be used, and you know, how to make sure that we have complete consent from people, and you know, really think about how we share our models. So there's something called ethical sheets, which we have started to produce in this community, and this will be sort of summarizing different areas within natural language processing and I assume in AI more broadly, where we kind of educate the researchers in our area about the potential implications of our work. So I think there has to be some kind of soft regulation, like voluntary standards at the point of development of the technology. But then once there are products and outputs, how these are shared and put into the real world, then there has to be more regulation, especially in terms of who uses it and for what purpose.
Yeah, thank you. That's very helpful, and it partly answers the question which Simon Chesterman has put, which really goes to the heart of what we're talking about today. How do the panelists see the relative role of A, industry, B, governments, and C, regional intergovernmental organizations in managing the risks and opportunities of AI? Who should take the lead and when? And I'm going to put that, first of all, to Kin for his view.
Thank you. I would say let's start with acknowledging.
Sorry, can I just interrupt you? And could the panelists answer the questions in the chat, which are directed to them? That's probably the easiest way. Actually answer them by typing answers to them, and then the more general questions like this one we can deal with. Sorry, Zikin.
Yeah, sure. I think that we should start with recognizing that artificial intelligence, right, is a technology, a horizontal technology. It will find its application in various sectors. I think we need to understand that first, right? And coming from the perspective of a policymaker and someone who has to regulate, right? You need to first, to introduce hard regulation, you need to have very clear problem statements of what the problem is, right? You also need to have a very clear idea of what the policy objectives are going to be, right? And with these two in mind, right, you can probably see where I'm headed towards. That I've got a bias towards taking a soft law, softly approach first before we move into hard regulation. Now, as we are moving towards regulation, as we are moving in this direction, I would say that industry as well as governments have to work together, right? Because I think in an area like this, which is deep in science and technology, right, the industry needs to help us formulate the tests that we want to apply, the kind of the metrics that we want to apply. If you talk about AI in autonomous vehicle, you're able to say that okay, it should perform to this kind of safety specification. It should be able to avoid this kind of accidents. It should be able to perform consistently in this environment. Now, these are details that the industry is in a position to inform the government as we are setting these as benchmarks and matrices, right? When we are working towards hard regulations, right? But at this point in time, the technology is still emergent, right? So let's work to articulate some of these things and let's let them stabilize before we start moving them into hard regulation. And I think that as we are doing all this, right, I would say let's keep an eye on interoperability, but let that not be the key driver, because many of these things we need to sort out within our own countries before we can actually take the next step. But we should have an eye that eventually, because of the nature of technology, how technology is introduced and propagated across the globe, right? We need to, from the very beginning, keep an eye on the need to be interoperable in a very near future.
Thank you. And Professor Zong, what's your view on this? I think in particular, it would be interesting to hear your view about the international aspect of this too.
Okay, this question is a very interesting question. Okay, how to say? I think all the law or regulation or the rules should be based on different rights, different obligations, and on corporations. If I had to make a decision which one should lead should be the role of a leader. My opinion is the industry, lead the industry. Only in the way of industry's development, we can find what are the opportunities, what are the risks, what are the challenges. Okay, after that, government could be involved together to make some rules. Okay, but government is just one role in the lawmaking procedures, and international organizations is also very important. They can be helpful to make some, unified agreement, unified standards, whether hard law or soft law. Okay, that's my view. Thank you, Lajun.
Thank you. So you think that there's a role for the international organizations, but it could start with soft guidance, if you like.
Maybe first step is soft law.
Maria, do you disagree with anything you've heard there in terms of, I mean, do you think there is any cultural difference in a sense between, say, the Singaporean or the Chinese approach in Europe at all on this? Are we plunging into regulation when we perhaps should be, or hard regulation when we should be starting with softer regulation?
Yeah, I mean, I do, as I said before, I think that at the stage of innovation, you want to have sort of the soft standards, the voluntary standards. I think Singapore has it right. But I do think that at the point of, so where I'm not so clear is when industry is involved and it's no longer sort of the R&D experimental stuff in industry, but what goes into production and wide use. I mean, I think there probably needs to be a bit more regulation, but I'm not sure whether this should be coming from which exact organizations this should be coming from. So I guess really being very clear about the importance of adhering to the voluntary standards. So this is actually a question I had for Zikin in terms of, how well is this working in terms of the different sectors? Do sort of some sectors tend to, adopt the voluntary standards more than others? And how do we actually motivate industry to follow the voluntary standards if, perhaps this means, extra costs to them to be probing or testing certain things. So I agree that hard regulation is not great for innovation in this area, but then I'm kind of, I would like to know about more about how we actually motivate industry to follow the voluntary standards.
Thank you very much, Maria. And so really, we've got a sort of qualified agreement between our panelists. I didn't manage to have an outbreak of discord quite, but we do have a bit of a proposition that I hope that the panels later in the morning will be able to debate to some degree themselves, because I haven't stated my view, but I think there's a gradation really depending on the risk involved. And I think a lot of the debate is going to be, A, what the risks are, are there such things as unacceptable risks? And then B, what kind of tools can we develop which will assess those risks in a common way so that we do get some kind of international agreement, so we don't have real problems in terms of cross-border use of various applications and so on. But no doubt we can continue to debate these things, and I'm extremely grateful to our panelists. There's so much to talk about and so little time for each of our panelists to unpack their thoughts, but I'm very grateful, and thank you for starting off the day so well. So I'm going to hand you back to our hosts. I don't know whether that's Guan. Hello, Guan. I'll hand back to you. Thank you very much.
Thank you very much.
Thank you so much, Tim. That's a wonderful keynote session. And ladies and gentlemen, I know you cannot join me physically, but mentally, let's do a round of applause to Tim and the wonderful speakers. Thank you very much. So our next session will start at 10:20. And of course, as Tim said, we hope this is just a very small starting point for our continuous discussion in the coming hours, as well as in the coming days, months, and years. Once again, thank you so much, Tim, and thank you, our keynote speakers.